Good afternoon, everyone. It is my pleasure to greet you here on behalf of the Fourth Circuit, to welcome our friends, and of course our Fourth Circuit family here for this wonderful occasion where we honor and commemorate the founding of our Constitution in 1787, and September the 17th, it'll be Sunday this year, that we remarkable founders came together. It's amazing when you think about it, what happens when you're an overachiever. Because at Annapolis, the meeting in Annapolis, they were only assigned to just make some changes to the Articles of Confederation. But instead, they came out with a new document and a new government with a lofty goal indeed. We, the people of the United States, in order to form a more perfect union. And I think they said that just to give credence to the people who wrote the first document, because yours was perfect, but this is more perfect. And to establish justice, to provide for the common defense, to promote the general welfare, to do those things in terms of justice, to secure the liberties and the blessings of liberties for themselves and their posterity. What lofty goals, and we are the recipients. And this first commemoration of the Constitution, I could think as chief, no better way to commemorate that than to honor young people. Because we pore over the Constitution every day in the Fourth Circuit and the judiciary, but if this republic will remain, as Ben Franklin said we have, it's young people, the next generation. They are still believing in its power and its purpose and its principles. And therefore we had an idea we'd have a contest. And at first we thought we'd roll this out small, but thanks to Judge Wynn's good vision, he said, let's do it big the whole way. So we did all the Fourth Circuit and all the 5 states. We invited high schoolers to participate, and we got 102 applicants and submissions. And we had a wonderful panel. We made sure we were out of the judging. Instead, we had experts to do so, and 2 of them are here. Professor Carr from Wake Forest, Professor Chambers from University of Richmond School of Law. Thank you so much. The other members are listed in the program. And let's give them a big hand for their hard work. I just want to let you know to make sure the winners this year, for our first year, from Virginia, Maryland, and North Carolina, but I want you to know that the judges only had numerical numbers on their papers. They didn't know what states they were from, who they were. All they did was, as Lady Justice does, blindfold themselves to all of those unnecessary things and stay within the 4 corners of the documents of the mission at hand. Thank you so much for that. And very brief, I want to just say that thank you so much, Pat Connor, our illustrious clerk of the court, and to Sarah and Joe and Jocelyn. They did a wonderful job. It is just so nice to have people, not just because it's their job to do things that the chief might ask them to do, but because they genuinely love doing it. And I might say that we hosted a group from Kenya here a few weeks ago, and they were just wonderful, and the Fourth Circuit hosted them. And lastly, I want to say about the Constitution. You know, we're, 230-some years away from it, but their Constitution is 2010. And they have so far to go, but I love their spirit. They were so enthusiastic about, and they're here trying to get public access, not public access, but legal access for the poor. And they have rather nascent in their task, and capacity is their challenge, but will is their engine. And when you have the will, you will find capacity. And I hope that this program will inspire you as these young people will today. First, our 3rd place winner, John Ford, unfortunately, could not be with us today. Again, scholars are always busy. He's in a baccalaureate program, and he could not get away from it, North Carolina. But I will tell you a little bit about John, 3rd place winner. As I said, he could not be here. He's a junior in the International Baccalaureate program at Marvin Ridge High School in Waxhaw, North Carolina. Judge Wynn, you know where that is? Union County, thank you. And his excellent essay on access to justice is in your program. And I'll be sure that he receives his certificate and his recognition. And along with that recognition with the certificate will be a check for $1,000. So we're videoing this. So I want to say, if I can look directly in the camera, John, this is for you. Thank you for your scholarship. Thank you for making this a wonderful first time for the Fourth Circuit to commemorate the Constitution. And good luck in your school year. Wish you well. And the check literally is in the mail. Thank you, John. And now, Sarah, if you will come up and introduce our second place winner and for his presentation. Thank you.
May it please the court, Chief Judge Gregory, circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing the second place winner of the first annual Fourth Circuit Essay Contest, David Edimo. Joining David today from Silver Springs, Maryland, are his mother, Mary Edimo, and his father, Okon Edimo. If you would please stand so we can welcome you. The beautiful accent that you may hear when you are speaking to them is because they are originally from Nigeria. David is a recent graduate of Richard Montgomery High School in Rockville, Maryland, and is now pursuing a Bachelor of Arts degree at Yale University. He plans to continue on to law school and eventually serve in the public sector. David's interests include jazz music and modernist art. He is particularly a fan of Rothko's work. It is my pleasure to present David Edimo.
All right. Thank you, everyone. Thank you, Mr. Chief Judge, Sarah, Madam Clerk, judges. My name is David Edimo, and I'll be reading the essay that I wrote for this contest. Due process, the great constitutional equalizer. When a scared 14-year-old girl walked into our office clutching her phone and in need of help, I saw the face of Captain John Preston. Preston lived 300 years earlier, but they both faced similar dilemmas. Confronted by an intimidating criminal justice system, they looked to someone for sympathy and help. Captain Preston, charged with murder at the Boston Massacre, turned to John Adams. This girl, facing a drug charge, turned to us at the Public Defender's Office, where I interned. For me, their connected experiences exemplify access to justice. The idea that both a wealthy British officer and a young Latina girl are entitled to a zealous defense. The Constitution is a critical part of ensuring this equitable access to justice. Preston hired a private attorney, but the girl in our office depended on her right to court-appointed counsel under Gideon versus Wainwright. Thankfully, the Constitution is laced with protections that ideally provide every American with a fair opportunity to defend themselves from charges. Still, there is more work to be done to fully realize its promise. Though the most well-known due process protections are found in the Bill of Rights, we see protections weaved in throughout the entire document. Article 1, Section 3, the Impeachment Clause, and Article 3, Section 2, which establishes judicial power, are prominent first instances. Ironically, the Impeachment Clause protects perhaps the most powerful people in the world, the President of the United States and other civil officers. Though they may be impeached by a majority of the House of Representatives, they can only be convicted and removed by a 2/3 vote of the Senate. Furthermore, the President's trial is presided over the Chief Justice. This is because, in the same spirit as the guarantee to an impartial jury, these procedures help mitigate the influence of politics in a highly charged environment. This vindicates our core belief that no individual should face punishment unless a certain burden is met. And with every additional vote required to convict an impeached officer, the likelihood of a politically motivated conviction, rather than one for high crimes and misdemeanors, becomes less likely. Although these protections apply to very few individuals, they are epitome of access to justice because even unsympathetic parties are insulated from abuse. Another important protection is found in Article 3, Section 2, which provides that the trial of all crimes shall be held in the state where the said crime shall have been committed. Like the ordeal with Captain Preston, this is a lesson that we learned from our revolution. Our colonial overlords routinely removed trials of crimes committed in the colonies to Britain for political expediency. This section prevents forum shopping and ensures that the community of a specific jurisdiction can pass judgment on an offense committed within that jurisdiction. Americans likely find most comfort in the access to justice protections found in the Bill of Rights and other amendments. Specifically, the 5th, 6th, 7th, and 14th Amendments have major implications for an individual's ability to protect themselves against the power of the state. The 5th Amendment's requirement, the defendants be indicted by a grand jury, is perhaps the most critical safeguard against malicious prosecution. It is also one of the purest manifestations of democracy in our constitutional system. Citizens are able to literally tell the government whether or not they will permit a prosecution to go forward. However, for a number of reasons, this clause hasn't been incorporated by the 14th Amendment to apply to state trials as well. While this might be more efficient for a prosecutor, it leaves a gaping hole in our system of checks. The 6th Amendment protects the right to a speedy and public trial, an impartial jury, confrontation of the witnesses against one, and access to counsel. This is arguably the most important amendment when it comes to access to justice. Without this amendment, the state could effectively imprison a defendant for an extended period of time while supposedly awaiting trial. An impartial jury ensures that there's a legitimate chance at convincing that jury of your non-guilt, and the access to counsel and ability to confront witnesses ensures that one can truly present the best defense possible. Attorneys are virtually required in felony cases to be able to successfully navigate the complex maze of criminal procedure. And that's why the girl charged with a drug offense had to come to our office. She needed the expertise of our lawyers to ensure that her rights were defended and so that professionals could examine the evidence and witnesses and force the state to meet its burden. The 7th Amendment protects the right to a jury in civil trials, which can be just as injurious to personal liberty as criminal ones. The 14th Amendment is a major key to these rights because of a doctrine known as incorporation. A vast majority of cases play out in state courts, but as written, the Constitution only applies to federal situations. But because of a series of Supreme Court decisions, many rights have been incorporated to also apply at the state level. Without this mechanism, hundreds of thousands of defendants would go without crucial rights. For many, justice means getting a preferred result. But to me, justice is done when each side of a dispute has a meaningful opportunity to present a robust argument for themselves. It has special meaning to me as someone who has seen the justice system up close through the eyes of a public defender and as a first-generation immigrant in a community that has a healthy skepticism of authority. Whether for the benefit of someone like me or someone like Captain Preston, it's important that the Constitution ensure that the awesome power of the state is exercised judiciously. With chronically underfunded public defenders' offices, gargantuan court backlogs, and other issues, it's not yet reality. But it can be, it must be, and we will make it so. Thank you.
David, on behalf of the Fourth Circuit and the full family of the Fourth Circuit, it is my honor and pleasure to present you with this certificate. And also, I believe there's a check for $1,500 in here as well. You know, it's one thing about having your mom here, you get the inside stories. I had lunch with him. And let me say thank you, and also to Judge Wilkinson and Judge Harris. I thought it'd be wonderful, since we have a new Eli here, to have him have lunch with two seasoned, one more than the other season. Eli, and it was just wonderful. I would say your mom told the story when David was in the 3rd grade. True story, because mom told it. It's always true when mom tells it. Mom said he wrote a letter to Harvard. He'd said, ladies and gentlemen, to whom it may concern, I'd like to know what is the path to get accepted into your school. Harvard wrote back, and his mother said, my goodness, has David been accepted to Harvard already? But it was not an acceptance, but it was to acknowledge his inquiry and to cheer him on. But it's funny how things go. Harvard had the chance, and they seized it, and they admitted him, but David turned Harvard down and went to Yale. So he got the information, but I guess that was for his information only. David, thank you so much. Here's a certificate, and this is the check. Look that way. Now, Joseph will introduce our first place winner.
May it please the court, Chief Judge Gregory, the circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing the first place winner of the first annual 4th Circuit Essay Contest, Rebecca Thompson. Joining Rebecca today is her mother, Esther Ajao, would you please stand, cousin Betsy Edimo, as well as her uncle, Isaac Parker. As noted in the program, Rebecca is an incoming senior at the Cecil D. Hilton Senior High School in Woodbridge, Virginia. Among her interests not included in the program are church activities and volunteering at her local hospital. Without further ado, Rebecca Thompson.
Thank you, Chief Judge Gregory. Thank you, Mr. Coleman. And thank you to all the judges present and all the distinguished guests. My name is Rebecca Thompson, and this is my essay on what access to justice means to me. In the United States, justice serves as one of the main principles that has been established as a cornerstone of the nation's foundation. The preamble effectively conveys the nation's commitment to justice with its statement that the citizens of the United States established the Constitution to establish justice and secure liberty for all citizens. Access to justice is essential to the administration of fair and proper justice for citizens of the country. Unfortunately, for the nation's poor, access to justice is not always readily available or easy to attain. However, the nation's justice system as a whole has made great strides for the poor's access to justice. The passage of laws that adhere to the amendments of the Constitution has made it easier for the nation's poor to easily have access to justice. Despite our nation's progressive movement towards adequate access to justice for the poor, there is still work to be done to ensure that the poor have proper access to justice in order to receive fair judgments in legal matters. Access to justice means being able to easily acquire justice without financial struggles serving as barriers to the administration of justice for the poor. The Constitution and Bill of Rights advocate for justice for all citizens, which proves that a citizen's economic status should not deter their access to justice. Moreover, no matter an individual's race, gender, or in this specific case, economic status, they have a right to have accessible justice. Several amendments to the Constitution exemplify the nation's commitment to equal access to justice for citizens who come from poorer backgrounds. In regard to the Bill of Rights, the Sixth Amendment establishes a citizen's right to counsel in criminal proceedings as a way to ensure that poverty does not sever one's access to fair justice. Similarly, the Eighth Amendment prohibits the requirement of excessive bail or fines from citizens as a way of guaranteeing one's right to justice no matter their economic status. Apart from the Bill of Rights, the 14th Amendment's Equal Protection Clause prohibits the denial of due process or, as the name suggests, protection under the law to citizens due to bias or discrimination. Consequently, under the 14th Amendment, poor citizens cannot be denied due process due to economic bias. These amendments represent the Constitution's promise of access to justice for citizens despite their economic brackets. Despite the Constitution's vow of access to justice for the poor, currently the poor have limited access to justice in regards to civil cases. In the United States, poor citizens do not have proper access to justice simply because their financial situation prohibits them from accessing fair legal aid in civil cases. According to Carrie Johnson, a justice correspondent for the Washington desk, many of the nation's poor lack access to lawyers in the face of various civil issues. This is because in the United States, it is not mandatory for citizens to be provided legal aid for civil cases. This lack of legal representation in civil courts translates negatively towards the outcomes of the cases for poor citizens. Studies show that when low-income citizens lack representation in civil cases, they tend to have trouble navigating the court system, which directly translates towards failure in court proceedings. If these poor citizens were to have access to legal representation, they would have more success in their cases and they would be delivered effective and fair justice. However, it is clear that the access to justice connection for citizens of lower incomes has been destroyed simply because they lack the funds to pay for proper legal aid or representation in civil matters. Despite the limited access to justice for the nation's poor, the Justice Department of the United States has worked and is working towards improving poor citizens' access to justice. The first step towards making justice more accessible to the nation's poor was the court decision in the Gideon v. Wainwright case of 1963. This Supreme Court decision aligned with the Constitution's 6th Amendment and held that citizens facing serious criminal charges had a right to legal representation if they could not afford one. Since then, there have been numerous court cases that have ruled in favor of the Constitution's commitment to justice for citizens of low incomes. The 2015 Vorden v. City of Clanton case ruled that bail payments in exchange for pretrial release were in violation of the 14th Amendment's Equal Protection Clause and unfair towards poor citizens. The 2016 Curran et al. V. Luzerne County case ruled that the county's underfunded public defense system could give rise to a violation of the 6th Amendment because citizens were not being provided with legal representation during their criminal proceedings. This year, one case, Walker v. City of Calhoun, Georgia, involved a plaintiff who was forcibly detained in jail for 6 nights because the plaintiff could not afford to pay the $160 cash bond for his release. The actions by the City of Calhoun were deemed unconstitutional and in violation of the Constitution's 14th Amendment in the court's decision. These court decisions are hopeful indicators of the nation's current progressive movement towards enhanced access to justice for poor citizens. Similarly, the U.S. Justice Department has launched an initiative called the Office for Access to Justice to enhance the poor's access to justice by providing criminal and civil legal aid to those who cannot afford it. Justice serves as a foundation to our nation's legal system. The Constitution and Bill of Rights uphold everyone's right to access to justice by making amendments inclusive for all citizens. Consequently, the nation's poor citizens also have a right to have access to justice despite their financial situation. Although laws have been passed to ensure the poor's access to justice, the poor continue to lack legal aid in civil cases. The U.S. Department of Justice should work towards making justice more accessible for the poor in civil matters. The guarantee of access to justice for the poor would fulfill the Constitution's promise of justice for all citizens. Thank you.
It's amazing how people know how to stay at the podium, not to take a bow, but to get a check. They don't leave. Rebecca, on behalf of the Fourth Circuit, the entire Fourth Circuit family, it is my pleasure and honor to present to you this certificate, which I hope you will remember for many, many days to come, of this time when our roads met and you enlightened our way, as David has as well. Thank you so much. And here's your $2,000 check. But don't think you're going to get away without a little antidote from the relatives. That's the problem with bringing family with you. This time it's an uncle who threw you in. I said, well, tell me about Rebecca. He said, well, Rebecca, when she was the smallest thing, if you opened the door, she was out of that door running. I mean, there she is, find her, because she's gone. And she's translating that swift of foot into a wonderful track star. She's a senior, as a track star, and she's looking at universities. She is indeed the scholar athlete. And so thank you for running, and thank you so much for your hard work and your scholarship. Well, that brings our program, the celebration, to conclusion. Thank you so much for being here. You know, when, as you know, our founders stayed in that musty room for 4 months from May through September. And in those days, the press was a little different, but still very, trying to find the scoop. So in spite of how hot it was in Philadelphia, they had to close the window so they couldn't be heard. So you can imagine what the temperature went up with the frock coats and the collars and the whole time. But anyway, Benjamin Franklin said, the chair that Washington sat in, who presided, who said very little, but the old man was there, the old general. He held things together by his very spirit. But he sat in a chair that had a horizon in the sun. And Franklin said, you know, I've looked at that chair all these 4 months, and I never could figure out, was that a rising sun or a sitting sun? Well, I don't have the benefit of Washington's chair, but I saw and heard 3 great, and read John's and heard from David and Rebecca. I know that today, indeed, that was a rising sun. It's a rising sun on our nation, a great spirit and a wonderful future, and we'll keep it if we keep them engaged and understand that this thing we call the Constitution, it lives, it's alive and breathing because of generations to come like you. Thank you so much for what you represent for our nation, for the youth, for our future. God bless you, and God bless the United States. These proceedings are closed. We're going to come down. We're going to have the judges, if you would, come by and greet them as we proceed out. And I invite you all to a wonderful reception that will be in our library on the first floor, and you can greet them, press their flesh, meet their families, and bask in the wonderful sunshine of our Constitution. Thank you.